Live streaming is on.
ಸರ್ ಕಳಿಸಿದ್ರ ಸರ್? ಹಲೋ ಸರ್.
ಹಲೋ.
ಕಳಿಸಿದ್ರ ಸರ್?
ಹಲೋ.
ಹಲೋ ಸರ್ ಕಳಿಸಿದ್ರಾ?
ಕಳ್ಸಿದ್ದೀನಿ ಮೇಡಮ್. ಏನೇನು ಬರುತ್ತೆ? ಮೇಡಮ್ ಮೇಲ್ ಮಾಡಿದ್ದೀನಿ.
ಹಲೋ ಸರ್, ಹರಿ ಸರ್.
ಹಲೋ.
ಹಲೋ ಸರ್.
ಹಾಂ ಹೇಳಿ ಮೇಡಮ್.
ಸರ್ ಇದು ವಾಟ್ಸಪ್ಪೇ ಮಾಡಿಬಿಡಿ ಸರ್. ಅದು ಯಾಕೋ ಬರ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ. HOD.isc.vkit@gmail.com ಅಂತ ಹಾಕಿದ್ದೀರಾ ಸರ್. ಫಸ್ಟ್ ಒನ್ ಇದರಲ್ಲಿ VKIT ಬಿಟ್ಬಿಟ್ಟಿದೆ.
ಓಕೆ ಫಾರ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ ಮೇಲ್. ನಿಮಿಷ.
ಹ್ಮ್.
ಮೇಡಮ್ ಇವಾಗ ಕಳ್ಸಿದ್ದೀನಿ ನೋಡಿ. Due to a technical glitch, so it was due to improper connection. So the connection will last for a few seconds, a few minutes. So we'll continue the session. So on the intellectual property rights, as you can, as you are all aware of the research and developments regarding any products. Okay, with the development of technology and lot of business tactics in a prevailing scenario, what has happened is like each and everyone has developed.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಇರಿ ಸರ್, ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಈಗ ನಾವು ಲಿಂಕ್ನ ಎಲ್ಲರಿಗೆ ಶೇರ್ ಮಾಡ್ಬೇಕು. ಈಗ ಅದು ಸ್ಟ್ರೀಮ್ ಆಗ್ಲಿಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು.
Okay,
ಇದ್ ಮಾಡ್ತೀವಿ ಸರ್.
Madam, shall I start?
ಸರ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಸರ್. ಹರಿ ಸರ್. ಹಲೋ
Hello.
ಹರಿ ಸರ್.
ಹೇಳಿ.
ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. ಸ್ಟಾರ್ಟ್
Due,
ಮಾಡಿ ಸರ್.
due to some technical problem, there was a delay in the webinar of the second session. So we'll start with the intellectual property rights. So intellectual property rights are like any other property right. They allow creators or owners of patents, trademarks, or copyrighted works to benefit from their work or investment in a creation. IP is a property which cannot be touched or seen and is product of persons' intelligence, hard work, and skill. Like real property, it can be bought, sold, licensed, exchanged, given away. The owner can prevent unauthorized use and can take legal action in case someone else uses it without permission. The word intellect refers to creations of mind. Intellectual property is a type of intangible property and includes inventions, literary and artistic works, symbols, names, and paintings. IPRs are the protection granted to the creators of intellectual property by the government. IPRs are territorial in nature. For protection of IP in any country, one has to seek protection separately under the relevant laws. There are special mechanisms in place in various territories for providing protection to different types of IPRs. Due to the research and development, so in that case, that is to reap the benefits of out of those R&D, people usually go for patents. Madam, next slide. So due to the creativity of a person, the he uses his idea to create a product or to create some designs, so that can be patented. So under various types, it may be related to the copyright or trademark, geographical indication, design, pet, semiconductor, IC layout design, trade secret, and plant variety. These are the types of IPRs. Madam, next slide. Copyright is an exclusive legal right granted to creators on expression of an idea. It may be related to the music or the books, or it may be biographies and also the papers published. It will be related to the researcher or the research person who is involved in that work, particular work. Copyright owner has rights to reproduce, translate, adapt, perform, distribute, and publicly display the work, etc. Registration is not mandatory since copyright comes into existence as soon as the intellectual work is created. It is recommended to register a copyright for better enforceability since registered copyrights have evidentiary value in court. To reproduce the work in a material form or to publish the work, to perform work in public, and to produce or reproduce, perform or publish any translation of the same work, to make any cinematograph film or a record in respect of the work, and to communicate the work by broadcasting using the radio or cable or satellite, to make any adaptation of the work in their individual works, to do in relation to a translation or any adaptation of the work. However, a copyright registration is a strong proof of your ownership. So mark your copyright work with the C in a circle symbol, your name of your creation, your name of year of creation. Okay. And these are the works which are covered under the Copyright Act. It may be a literary, including softwares, for example, Windows software, Windows 10, and other software that is mobile software that is Android, and it may be Apple OS. And artistic works, that is drawings or paintings, and it may be the logo of any product, and the maps or the charts, and the work of architecture, architectural designs, and dramatic works. It may include screenplay as well as the drama created by an artist or the director, and the musical notations which are created by the musicians, or it may be by a group of musicians, or it may be a single person. And sound recording, it may be related to the nowadays. So compact discs are out of the order. So uh, you can download the music from the internet, or it may be many from the internet platforms, or many apps are available nowadays. They take the permission of the publisher, the musician who has created the work, and that has to be broadcasted in their channel, or it may be in the app. And cinematograph films. So nowadays, due to the rise of COVID pandemic, many of the movies are and web series are released on the OTT platform like Amazon Prime, or it may be Z5 or Disney Plus Hotstar. So they have to take the permission of the producer. They have to purchase it from them. They have to pay the amount required for the purchasing of that particular movies, or the short films, or it may be web series, and it has to be used. So these are all the works covered under the copyrights. Next slide, madam. And the works covered, the time period, that is the Copyright Act provides the time period, certain time period for these works. For literary and dramatic works, or musical or artistic works, it grants lifetime of the author and until 60 years from the death of the author. And for the anonymous and pseudonymous works, that is maps, or it may be architectural works, 60 years from the year the work was first published. And the works of public undertakings and government works, the 60 years period from the time, from the year the work was first published, will be provided. And the works of international organizations, it may be World Health Organization, or UNESCO, or any other world organizations, international organizations, 60 years from the year the work was first published. Sound recordings, it may be related to the instrumental music, or any other music related to the movies, or the web series, or the short films, 60 years from the year in which the recording was published. And cinematograph films, 60 years from the year in which the film was published, will be that will be prevented, sorry, the copyright will be prevailing up to 60 years for these types of works. Okay, next slide, madam. And another part is a trademark. It is any name, word, or sound, numerical color, symbol, or drawing, or their combination. Trademark lets us identify the goods made or services offered by a company or an individual. A trademark should not be identical or similar. Following things can be registered as a trademark. It may be a word or a combination of words, letters, numerals, drawings, symbols, and it may be three-dimensional symbol in a single brand or logo. Trademarks can let you know many things about a company's reputation, its products, and the services offered by that particular company. For example, Maharaja Mac is a word mark for burgers of the international fast food restaurant chain, McDonald's. Other types of trademarks are a logo, that is, for example, Google logo, and packaging, that is, Pepsi bottle packaging, a service mark, it may be Vodafone for mobile phone services, and other non-traditional trademarks are even as sound, smell, color, or combination or shape can be a trademark under certain circumstances. Presenter can give examples of, that is, the example can be taken for Coca-Cola bottle. You can the can, bottle shape, and the MGM. For example, in movies, the picture production company MGM, the sound of the lion roar, that is a sound mark. A trademark is a mark accorded with protection intended to serve the purpose of recognizing the source or origin of the goods or services to which the particular mark belongs. It is a symbol of origin and source of a mark and bears the stamp of quality. Trademark owner would always want to protect his mark from unfair usage and also from fraud and deceit. Madam, next slide. The essentials of a trademark are: it is advisable that to use the unique uh, symbol, and it should be distinctive, and it should also be non dictionary words or invented words and custom designs, devices or symbols. Example, make in India is a symbol used for the products which are manufactured in India or the goods, and non descriptive. Example, goods. You should go for a trademark which is easy to speak and spell in case of word mark, and it should be appealing and easy to remember or recollect, and it should be invented or coined word, unique monogram, logo or a geometrical device, and the which we should avoid these things, that is adjectives, use of adjectives, that is efficient product or efficient working system, like that, and names of the persons or places, and obscenity, religious or constitutional words or symbols. Example, Om or Ashoka Chakra should not be used in the trademark for any product, and common shapes, example, spear, should be avoided. We should not go for trademark which consists of, that is laudatory or descriptive matters such as best, perfect, super, etc. words or pictures of the product concerned. And also we should avoid geographical names, that is common surnames, names of a community or persons, and we should avoid a matter prohibited by the law to be used as a trademark, and a matter that is same or similar to an already existing trademark in the market should be avoided. Okay, and next slide, you'll come to know what is meant by trademark, and so how to indicate the trademark. So trademark, that is indicated by TM, that is that sign is used when a trademark has been filed and the registration is under process. And you can recognize a registered trademark by the symbol of a circle or following the trademark name or graphic image. Trademark sign shows the brand name for an unregistered trademark classified as a product. The owner uses this sign to mark what they believe is their brand mark. Use the symbol of a circle once you register a trademark or service mark. It shows that country authority has approved the registration of your product. Next content is a patent. Patent is an exclusive right granted which provides the exclusive right to exclude all others and prevent them from making the product or using this patent and offering for sale or selling or importing your invention. What is meant by invention? An invention in simple terms refers to a new product or process which is a technical advancement over the existing knowledge or has economic significance or both. For example, television, telephone, internet, email, YouTube are all inventions. For an invention to be patentable, it needs to satisfy three criteria. It must be new, that is, it is not something already existing in the current knowledge anywhere in the world. That is not in public domain in any form. That is nothing but it should not be in existence already. It should not be used by others, or it is not in existence in the society before the filing of patent application. That is called as novelty. It must be non obvious to any person who is skilled in the relevant field of technology. That is, the standard is a person reasonably skilled in such field of study and not a layman. That is an inventive step. And third one, it must be capable of industrial application. It should be uh, it should have the wide applications for the society. That is practical utilities. It is capable of being applied to practical utilities and not just pure theory or industrial use. A person who invents a new car engine to run with water or waste material can, after getting it patented, further grant a license to use this technology to some big automobile company for certain amount of money. The automobile company can use this technology to build a new sector in the cars market. Okay. A patent is valid within the territory of country where it is granted. However, protection can be availed in other countries by filing applications in relevant patent offices. In India, that is Development Commissioner, that is MSME, Ministry of MSME, Government of India has sponsored establishment of multiple intellectual property facilitation centers, and Department of Science and Technology under Technology Information Forecasting and Assessment Council, TIFAC, has set up various patent facilitating centers, PFCs, throughout India. Madam, next slide. So these are some of the non-patentable inventions. That is, sections 3 and 4 of the Patents Act deal with non-patentable inventions. That is, frivolous invention or the one contrary to established natural laws is not patentable. That is a method of treatment of humans and animals that is not patentable. Inventions that cause serious prejudice to human, animal, or plant life or health or to the environment that cannot be patented. And computer program per se or algorithms, mere discovery of a new form of known substance. If the substance is already known, for example, mere discovery of any new form of a known substance, that is which does not result in enhancement of the known efficacy of that substance, or mere discovery of any new property or new use for a known substance, or the mere use of a known process. That is, for example, crystalline form of a known substance. That is not a new invention, okay, which does not comes under the patent. And mere discovery of a new, that is mere admixture resulting in aggregation of properties, mental act or method of playing game, that is not patentable. And presentation of abstract ideas, inventions containing traditional knowledge, and presentation of abstract, it is repeated, okay, inventions contrary to natural laws, mathematical or business method of agriculture, inventions which fall under the Atomic Energy Act, for example, manufacturing the bombs, or it may be nuclear weapons, that does not cover under the patents. It is not patentable. The permission will not be given for taking some patents on the military equipments or any other uh, explosible materials. Okay. Next slide. Some patented inventions are, that is during the election, that is indelible ink is used by the largest democracy in the world. Okay. It is developed by National Physical Laboratory, New Delhi, and the licensed company is, that is measures and sales, that is Mysore Paints and Varnish Limited. This ink is being used for election purposes for the last 40 years in India and abroad. Ink is indelible because it contains a silver compound which chemically reacts with the pigment of the skin when exposed to light, leaving a black color on the skin. The ink is being used not only in India but is being exported to more than 25 countries. And the second one, what we are saying, that is remote controlled power tiller. It is developed for making the work of farming easier, comfortable, and safer. It is an electromechanical gadget which goes as an attachment for power tillers. This technology offers farmer to operate the power tiller from a far off point without even getting into the field and stand peacefully under a shade, avoiding exposure to elements and irritating engine noise. This also eliminates the chances of injury to the operator while running behind the power tiller in uneven field. It is also quite helpful for women farmers. And third one, it is a cloth clip, and fourth one, it is a idli maker. So these are also comes under the patentable. It is already the patents are taken for these materials or these products. And next slide, a semiconductor integrated circuits layout design. Madam. As we all know, semiconductors are used in the computer, that is motherboards as well as in CPUs. It is integrated circuit, a product having transistors and other circuitry elements designed to perform an electronic circuitry function. It is also called as chips or microchip. These IC chips form an integral part of every electronic device like computers, television, electronic watch, mobile phones, etc. It is protected under the legislation, that is Semiconductor Integrated Circuits Layout Design Act 2000 and Semiconductor Integrated Circuits Layout Design Rules 2001. The layout design of a semiconductor integrated circuit means a layout of the arrangement of transistors and other circuitry elements expressed on a semiconductor integrated circuit. So, term of SIC. The Act provides for registration period of 10 years from the date of filing of an application from registration or from the date of its first commercial exploitation. Commercial exploitation here refers to acts of selling, leasing, offering, or exhibiting for sale or otherwise distributing such SIC for commercial purpose anywhere in India or in any country, whichever is earlier.
Next.
In next slide, it speaks about the design. Design, it may be industrial designs that is related to the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to product, which makes it look different from other articles in market. Purpose of industrial designs is to add on to the aesthetic value of the product to increase the marketability while making our life easier. To protect the designs, the Design Act 2000 governs the provisions relating to designs in India and specifically mentions that designs to be registered must be visible on the finished article. So before manufacturing the product, we have to submit the patent. We can apply for the patents. Whatever the description we are given in the patent to the patent office, that should resemble or bear when the product is manufactured. That is on the finished product or the article. For a design to get registration, it should have following features. It should be a new one, must be new. A new design does not necessarily mean a completely new one. It can also be the application of pre-existing design to a particular product for the first time. It should be original, not disclosed to public. That the design must not have been published or disclosed anywhere else in the world before filing or registration. So we can refer to the in Google patent search also we can refer whether the product has been already in market. So we have to check before applying for a patent that whether the product is already available in the market by using the Google patent search. And it should be not against public morality. It should be distinct in nature. and not functional in nature. That is, if any product has any functional feature without which the use of that product is not possible, then the design of that functional aspect cannot be registered. And the benefits of design registration are: it adds to the aesthetic value of a product, increases marketability of a product. Design registration can be used in quote, provides an exclusive right in the market and establishes a better license position. Design protection is provided for 10 years. The period of protection is extendable to 5 years after the expiry of 10 years duration. Next slide, you'll come to know about the essentials of a design. So it should be having the eye-catching feature, new or original, applicable to any article by an industrial process, should not be functional or useful, should not be of artistic nature like painting, sculptures, etc. The paintings or sculptures cannot be considered as design. Okay. It The following items can be registered as designed in India. That is, it should be new one, and it should be original. It should not be disclosed to the public. It should be distinct. It should not be not against public morality, and should not function in nature, functional in nature. The, fo- the following items cannot be registered as design, that is, book covers, calendars, certificates, because uh, in institution only, whenever we conduct the webinar or any other short-term training programs, we give the certificates for the attendees or the participants. So that cannot be registered as a design. And the medals offered given by the college to the students or any and in sports or cultural activities, that also cannot be registered as a design. And the greeting cards, postcards, documents, forums, etc. So these uh, materials cannot be registered as a design. Madam, next slide. So in this slide, you can see many of there are 5 pictures. So we have to point out the industrial design. So first one is not an industrial design; it is a painting. Okay, it can be covered under the Copyright Act. And second one is also not a industrial design; it is a sculpture that cannot be considered as a design. And third one can be considered as an industrial design. It is an industrial design. They have patented it for the design, also the Apple company, for its Apple tab, or it may be tablet and the mobile phones. And fourth one, Domino, that is a branding logo protected under trademarks. And fifth one, it is a industrial design. The bottle shape of the bottle is the industrial design. Madam, next slide. And next one, that is geographical indication. Geographical indication is primarily an agricultural, natural, or manufactured product like handicrafts and industrial goods. For example, that is Mysore silk. It is a geographical indication. We cannot, that is in any other parts of India, that cannot be used. That is this is a Mysore silk which is produced in, for example, in Andhra or Tamil Nadu. That cannot be treated as the Mysore silk. Okay. And second one, that is Rajasthani Kutbudils, that is the handicrafts. Okay. And the vegetable, that is Nago Mircha, that is a Darjeeling tea. So these are all the products which are the grown, or which are products developed in a particular region, that constitutes the origin. For example, Mysore silk, it is originating from the Mysore, and Kanchipuram silk. These are some of the examples which indicate the geographical location where it is originated first. Okay. Geographical indications in India is protected under Geographical Indications of Goods Registration and Protection Act 1999, and Geographical Indication of Goods Registration and Protection Rules 2002. India is a rich storehouse of goods with reputation for quality, which can be adduced to their geographical origin or place of manufacture. Need to protect Indian treasures. Okay, economic potential of these goods is enormous. to prevent GI geographical indication goods becoming generic. The registration for a geographical indication is valid for a period of 10 years. It can be renewed from time to time for further period of 10 years each. Madam, next slide. So these are the essentials of geographical indication. It is primarily concerned with the agricultural, background or natural or a manufactured product. It may be handicrafts and industrial goods originating from a definite geographical territory. And the benefits of registration of geographical indication are geographical indications, which in turn boosts the exports of the products which are grown here, the agricultural products which are grown in our country, promotes economic prosperity of producers of goods produced in a geographical territory. A trademark is a sign which is used in the course of trade, and it distinguishes goods or services of one business with those of other business. The geographical indication is an indication used to identify goods having special characteristics originating from a definite geographical territory. Madam, next slide. And this is another one, that is plant varieties. This is established, that is due provide for the establishment of an effective system for protection of plant varieties which are grown in India, that is grown by the farmers, rights of farmers and plant breeders, and to encourage development of new varieties of plants. The act was enacted to meet the obligation under Article 27 3B of the TRIPS, that is the PPV and FR registry started the process of receiving PVP applications for registration, that is Indian IP region, for the protection of eligible varieties of notified genera of crops, which with effect from 21st May of 2007. Various varieties are already registered, such as pearl millet, rice, black gram, types of green gram, types of maize, types of wheat, French beans, tetraploid cotton, diploid cotton. Okay. And next form. And these are some of the genetic resources and traditional knowledge. So these are all protected in the Indian traditional knowledge base. Okay. Examples of genetic resources are material of plant, animal, or microbial origin, such as medicinal plants, agricultural crops, and animal breeds. Traditional knowledge is knowledge, skills, and practices that have been passed on from generation to generation within a community, often forming part of its cultural identity. Traditional knowledge is crucial for the subsistence and survival of man, thus necessitating its passage from generation to generation. Knowledge comes from interactions with the community's immediate surroundings and environment. So why we have to protect this traditional knowledge? Because many of the communities which have preserved traditional knowledge still use it, and it is important to prevent the exploitation of this knowledge. For example, turmeric, it is used, and ginger. To prevent the exploitation of this knowledge for commercial gain by others. And the traditional knowledge being sustainable in nature is also important because it is environment friendly. It must be protected to prevent biopiracy or the unauthorized extraction of biological resources without compensation. Because many of them, for example, if you take the case of the natural resources available in India, some of them they export illegally. So to avoid this, we have to protect the traditional knowledge under this act. Madam, next. So to know the materials which are the natural resources which are from the age old ancient time, Indian government has set up traditional knowledge digital library in order to maintain the traditional knowledge. It was set up in 2001 by Council of Scientific and Industrial Research, that is CSIR, in collaboration with Ministry of Ayush. The objective of TKDL is to maintain the ancient and traditional knowledge derived from different Vedas as well as traditionally passed verbal knowledge, especially about medicinal plants and traditionally used formulations in Indian systems of medicine. It also serves as a non patent database search platform to encourage modern research based on traditional knowledge. It prevents patenting the traditional knowledge because the traditional knowledge cannot be patented as per this rules mentioned. Doc- TKDL documents Indian systems of medicine mentioned in Vedas, Ayurveda, Unani, Siddha, and Yoga. TKDL is used as a non-patent search database in 11 international patent offices. That is in outside India also. It is in United States and also in European Patent Office. They use our database, that is traditional knowledge database library, digital library. Madam, next slide. So last one, that is a trade secrets. It is any secret which is extremely vital for a company's growth and crucial for its survival. Business, entrepreneurs, companies, etc. ensure that they effectively protect their business process, technical know-how, and confidential information from rival companies or the competitors. Trade secret refers to any data or information pertaining to the business not known to the public, and rational attempts have been made in this regard for guarding the information as secret and are confidential. In most cases, such data or information may encompass an economic interest of the owner in obtaining an economic gain over rivals and competitors. The precise language by which a trade secret is defined may differ. However, there are three factors which can be said to be common to all such definitions. That is, they must not be known or readily accessible by people who usually deal with such kind of information, and must have commercial value as a secret. It should be the lawful owner must take reasonable efforts to maintain its secrecy. And this in India, it is national IPR policy is framed to make sure that the intellectual property rights is protected. That is for the benefit of all. And India, where intellectual property promotes advancements in science and technology, arts and culture, traditional knowledge. S- Madam, next slide. So these data are available in the website, that is in National IPR policy, and we will move on to the objectives of national IPR policy. Objectives of national IPR policy. The government has adopted national IPR policy with a view to building a dynamic, vibrant, and balanced intellectual property rights system in India to stimulate creativity and innovation and achieve socio-economic, industrial, and cultural development by promoting IPRs in the country. And to prevent the that is commercialization of IPRs to get value for the products which they have developed through their research. So, Cell for IPR Promotion and Management, CIPAM, is a professional body to effectively implement the national IPR policy. It conduct targeted IPR awareness programs across the country to strengthen and enforce through trainings and police officials and judiciary toolkit for enforcement prepared. Okay, so it is a national local point for technology and innovation support center by WIPO. It is working with states to establish IPR cells with universities and colleges. So as of now, many of the universities have started the IP cell and they have started filing the patent application. for the research works that has been carried out under the supervision of the research persons who are involved in it at their university or it may be at their institute level. CPAM is creating an online platform that will bring all IP stakeholders together. Task force on innovation working on improving India's rank in Global Innovation Index. So these are some of the patent rules and common features and trademark rules. So which are available, what are the facilities they offer for the and the rebate offered by them. That is almost existing forms replaced by 8 consolidated forms, express provision for filing applications for sound marks. E-filing is encouraged through 10% rebate in fees. Email now recognized as a mode of service. So due to this COVID pandemic, so nowadays physical examination is not taking place. The the mode of service is that is through the email. So we can convey the applications are can be filed and expedited processing of an application for registration of a trademark right up to the registration stage. And these are special provisions for the startups are provided, and it is simplified and a streamlined process are taking place now. Madam, next slide. So these are the benefits offered that is for the startups. So in our college also we have set up an incubation center to identify the to support the by providing the seeding fund for the entrepreneurs. Startups intellectual property protection, that is 50% rebate in trademark fees, and vis other companies 80% rebate in patent fees, vis other companies expedited examination and disposal of patent applications. So startup intellectual property protection is up to 31/3/2020. Government based entire cost of the facilitators who assist startups file and pursue their IPR applications. So these are some of the present scenario. Okay, benefits that I got in 2016 and facilitators impaneled under SIPP scheme, patent and trademark applications filed by startups. So 543 patents are filed, and till now, 473 trademarks has been approved. Okay. So nowadays they are doing faster examination to increase the patent filings. Okay, so these are the this graph indicates the growth of the IPR trends in the last from 2015 to 16 and 2016 to 17. So India on the global IP. Madam, next slide. So India on the global IP platform. So IPR is a key competitive asset in India's ability to compete in the global economy. A robust and balanced intellectual property regime is a crucial tool for advancement of innovation, economic growth, and international trade. So, as per the directions of the Ministry of Education's Institute Innovation Council, so we have to set up the incubation center, and we have to leave our students to individually think and try to come out with their ideas and to develop a product. So it should be innovative one and it should be useful for the society. And then we have to file a patent against that product. Suppose if it is socially useful, so it should be of a reasonable price. It should be uh, offered for a reasonable price. So we can file a patent against that product developed under the incubation center. Okay. India's ranking on Global Innovation Index, that is GIA, shot up from 81 in 2015 to 60 in 2017. Okay. So latest data is not available. It is the task force on innovation had the mandate of assessing India's position as an innovative country. So that is so next topic, that is IP infringement. Next slide, madam. Enforcement and remedies. See, IP infringement is any breach of intellectual property rights. IP rights are infringed when a work protected by IP laws is used, copied, or otherwise exploited without having the proper permission from a person who owns those rights. Examples of an IP infringement are counterfeiting and piracy. Counterfeiting is the practice of imitating genuine goods, often to inferior quality, with the intent to take advantage of the superior value of the imitated product. So, piracy is an unauthorized copying, use, reproduction, and or distribution of materials protected by intellectual property rights. Madam, next slide. So, counterfeiting, piracy, and smuggling are emerging as the likely sources for financing of international terrorist organizations, non state sponsored terrorist organizations, and domestic terrorist groups. The menace of piracy has also assumed significant proportions and is causing significant economic loss to the industry as well as the government. Unfortunately, India is one of its hardest hit victims. With rising use of digital medium, online copyright piracy is assuming gigantic proportions across the globe, and no country is immune to this menace because due to this digital medium, so we can see the crimes are taking place. That is, the money is transferred from the account of individual person without the notice, without any notice. mm. So, due to this counterfeiting and piracy or smuggling, and also the pirated softwares, the problem is not unsolvable. We need to empower IP owners to enforce their rights. We believe that innovative technology based solutions, stronger enforcement mechanisms, and awareness initiatives with the help of the industry may play a significant role to keep pirates at bay. Madam, next slide. Next slide, madam. IP laws in India are governed and protected under the Patents Act 1970, Trademarks Act 1999, Copyrights Act 1957, Designs Act 2001, etc. Civil and criminal remedies mentioned under these acts are of utmost importance of the IP rights enforcement. Civil remedies. Union IP infringement civil remedies can be enforced by filing a suit for infringement and are passing off in case of unregistered trademarks in the competent court. Injunction is prohibition of an action by a party to a lawsuit if the plaintiff establishes that the prima facie case is in his favor. Injunction is granted. So these are some of the online copyright piracy enforcement issues. There are number of intricacies involved in taking enforcement action against online copyright piracy, assuming gigantic